All right, let's get cooking. We're going to be looking at administrative law here. Next, we're going to be focusing on family law, and then we'll have two different topics relating to international law. But all we got to go through for now is administrative law. All right, so an introduction to administrative law. What is it? So, administrative law is the branch of public law that's responsible for regulating relationships, institutionally, interpersonally, technically, between the government and the public. It governs bureaucracy, as in it governs bureaucratic functions in the operations of administrative bodies that are established by federal and provincial governments, right? We talked about that a little bit, and we'll talk about it a little bit more. But yeah, the government, both provincially and federally, is responsible for the creation of different administrative bodies that are responsible for certain contextual relationships between the public and the government. Administrative law is responsible for governing this. Yeah, it's responsible for the governing the relationship between figures with legal personality. What is legal personality? We'll get into that. But since the 1970s, administrative law has expanded significantly, causing a broader range of government actions. So again, what is legal personality? This is going to be an important thing here in international law. So we might as well cover it. What is legal personality? Well, legal personality is the idea of having legally recognized rights and responsibilities. So the question is, who is part of this? Who has a legal personality? Well, human beings are natural legal persons, while businesses, companies, government institutions are non-natural legal persons. If you can sue and be sued, you have a degree of legal rights and responsibilities, right? So, yeah, you can have a natural legal personality and non-natural legal personality through being a natural legal person, like people are a non-natural legal person, like businesses, companies, whatever. But yeah, it's legal personality is having legally recognized rights and responsibilities. So again, administrative law is responsible for governing the relationships between figures with this legal personality. Um, Administrative law is also, and administrative bodies are a pretty good sign of a democratic society. It has two main facets. One, the idea that authority is deferred and delegated to administrative bodies to manage different relationships in society. And two, the government must ensure that the administrative bodies administer governance in a fair, good faith, and unbiased way. They must cooperate with accordance to the charter. So these are the two main ideas within administrative law, and administrative bodies as an extension of that. So what are the objectives here? One, we're going to introduce administrative law. Two, we are going to discuss the concept of delegation in government functions. Three, we're going to unpack the role and the nature of administrative bodies. And four, we will consider the role of judicial review in administrative decision making. Let's get into it. So, administrative law. The definition and the scope of administrative law. We already kind of touched on this a little bit, but we'll reiterate. So, administrative law regulates interactions between the government and citizens, ensuring the accountability of bureaucratic agencies. It encompasses laws governing government bodies such as regulatory agencies, tribunals, and commissions. It is a branch of public law distinct from constitutional law but closely relating to it. It does not stem from a single statute, but it is developed through legislation, regulation, and judicial decision, and it provides a legal framework for governing agencies to operate efficiently while protecting public rights. Again, administrative law is essentially the law surrounding administrative bodies. What do administrative bodies do? They govern the relationship. They manage the relationship. They stand as a middle ground of the relationship between the government and the people, right? So it only makes sense for administrative law to provide a legal framework for government agencies to operate efficiently while protecting public rights. Administrative law is a distinct form of public law. Administrative law is often referred to as day-to-day public law because it governs routine government interactions with citizens. It is a close relationship with constitutional law, as we talked about, but it differs in key ways. Some of these ways are that constitutional law establishes the framework of government powers and rights. Administrative law enforces and applies these principles. Okay, so administrative law is derived from constitutional law and fleshes out that constitutional practice. So, again, if constitutional law establishes the framework of government powers and rights, and administrative law comes from constitutional law and fleshes out these ideas, it would only make sense for it to then attempt to enforce and apply these principles in practice. So administrative law is also more dynamic as it continuously evolves to address government needs. And unlike criminal law or contract law, administrative law does not originate from one overarching statute, but instead it is formed through multiple sources, including regulations and case law. And finally, individual federal and legislative statutes will delegate authority to different bodies. So just to go over that, again, what we've talked about so far, right? Administrative law is separate from constitutional law, but they have a lot of interplay. Administrative law is governing administrative bodies, essentially, which by function are managing relations between the government and the people. So administrative law regulates the interactions between government and citizen. It's part of public law. It doesn't come from a single source. While constitutional law establishes the framework of government rights and powers, administrative law is more dynamic and it looks to enforce and apply these constitutional law principles in practice, as opposed to just being a framework. Delegation in administrative law. So, one, what is delegation? Delegation is the process by which federal or provincial governments transfer authority to non-elected administrative bodies. Not all government powers can be delegated. Some require elected representatives' direct oversight. Additionally, the government isn't passing on responsibility. They're delegating authority that they oversee. And this is a huge thing in administrative law, right? Because that's part of what administrative bodies are. They are a delegated authority being overseen by the government to manage government public relations. What is interdelegation, right? Interdelegation is when a federal government delegates authority to a provincial administrative body, like we just talked about. But additionally, we can see a provincial government delegating authority to federal administrative bodies. So we see the federal bodies delegating authority to provincial bodies, and the provincial bodies delegating authority to federal bodies. But it's important to remember, again, this isn't just body to body, it's government body to administrative body. Right, so the federal government delegating authority to a provincial administrative body, and a provincial government delegating authority to a federal administrative body. Okay, so we understand delegation, we understand what interdelegation is, but what are the functions and benefits of delegation? Delegation is a system, right? So delegation can assist with governance, right? It can help the government maintain and manage specialized tasks. It encourages specialization. Where we see experts handle regulatory functions more efficiently within their individualized bodies. We see an enhancement in flexibility, right, where administrative bodies can adapt regulations quickly as opposed to it being a usually more taxing, less efficient, less timely whole entire federal system. We see delegation provide discretion, allowing a case-by-case kind of decision-making style. We see delegation increase efficiency, as we kind of talked about, where administrative decisions can be faster than court rulings, for example, judicially. And we see delegation foster innovation, where we can see agencies develop modern approaches to regulation. So we have a pretty good understanding of delegation, right? It's delegating authority that is still being overseen by you, but you aren't specifically passing on responsibility. We can see a federal governmental body delegate authority to a provincial administrative body versus a provincial government body delegating authority to a federal administrative body, and this helps in several ways. It can assist with governments, it can encourage specialization, it can enhance flexibility, provide discretion, increase efficiency, and foster innovation. All right. The primary legal dynamics of administrative law. So there are three primary legal dynamics within administrative law. It is jurisdiction, statutory interpretation, and legal principle. So we're going to go through these one by one. Jurisdiction. So jurisdiction in administrative law is the result of delegation. Authority is delegated to authoritative bodies who then hold certain powers via specified legislation with regards to all kinds of things. So all administrative boards, who obviously have to follow administrative law, have specific jurisdiction. Jurisdiction is a key part of administrative law. We're going to look at two Latin definitions here. We have ultravirus and intravirus. So ultravirus is operating outside of your jurisdiction, and intravirus is acting within your jurisdiction. So in the case of ultravirus, right, you could see acting within their legislation and designated. I wrote this backwards. With ultravirus, we can see, someone operating outside of jurisdiction, right? A body operating outside of its jurisdiction, aka acting outside of its legislation, right? And its designated authority. In this case, the body's decisions and operations can be turned down. Oppositionally, we have intravirus again, where the body is acting within jurisdiction, aka acting within their legislation and designated authority. So this covers the jurisdiction element of administrative law. Statutory interpretation, right? Because boards are acting in accordance to legislation, they have to interpret the legislation in which they legislate under. It is up to the boards to interpret their authority via their legislation. However, if they interpret their legislation improperly and you feel like you've been handled unfairly, assuming that you're interacting with an administrative board, you have the right to file an appeal to acquire judicial review over that statutory interpretation. So when it comes to the biggest form of judicial review that we see in Canada is with regards to the review of administrative law, right? People feeling indignant with regards to how an administrative board has handled them, right? And finally, legal principles. Are these bodies properly applying Canadian legal principles as per the Constitution? Right? This is a key legal question within administrative law, and it's something to be examined. And the primary legal principle in administrative law is legal fairness. Is the notion of legal fairness being properly applied? Are different cases being treated equally? These are things to consider, right? So when it comes to all three of these things, any improper care taken when it comes to the execution of these different dynamics of administrative law, if it's a federal administrative body that is doing this, right, this improper care, they will be reviewed by the federal government. If the provincial body is the one that is acting carelessly or incorrectly, they will be reviewed by the provincial government. We'll talk about it a little bit more, and it'll be reinstated moving forward in the topic below. Um, and we did a little bit in topic 7, if I remember right. Yeah. 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 Let's talk about administrative tribunals, boards, and commissions, right? So these are government mandated bodies designed to handle disputes outside of the formal court system. They interpret and apply laws within their specific jurisdiction, as administrative boards do, and their authority comes from legislation and regulation. What are the functions of administrative bodies? Right, all of these are, these tribunals, boards, commissions, they're all administrative bodies, right? So administrative bodies perform a variety of functions. Right, so they adjudicate or they resolve disputes like courts, but with specialized expertise. They make rules, creating and enforcing regulations within their specific jurisdiction. Despite having this specialist nature, it's important to note that they will never override the position. They are not superior to the federal or provincial government. They develop policy within their specific jurisdiction, and as well as assisting governments in policy formulation. They research and they recommend different avenues of approaching legal matters, providing expert insight on them as such, and they allocate resources within their jurisdiction, managing public funds and services. Yeah, so again, the functions of administrative bodies are to adjudicate, make rules, develop policy, research, and recommendations, and allocate resources all within their jurisdiction. What are some examples of administrative bodies, right? We have things like, immigration, refugee, and citizenship administrative boards. We have labor relations boards. We have human rights commissions, right? Right. We have workers' compensation, welfare agencies, etc., etc. What's a key case here? We got one. It's Dr. Q versus the College of Physicians and Surgeons of BC. This is a case regarding the standard of judicial review and the standard in which justices are reviewing decisions made by administrative boards. So there was a complaint filed against Dr. Q for sexual assault with a patient, in addition to evidence of that sexual behavior. When the complaint was filed to the administrative body, they took the testimony of the accuser, but not of Dr. Q. A judge determined Q's punishment to be an 18-month suspension, as well as re-entry rules. Dr. Q took to the appeal, and upon appeal, the reviewing judge actually decided that the finding was unjust due to only considering the woman's testimony. A Supreme Court judge stepped in and determined that the appealing judge's opinions are irrelevant and that they should only have focused on the facts of the case, decision made, and the actions of Dr. Q specifically when it came to the standard of reasonableness. When it comes to judicial review, they're simply ensuring that the appropriate legal principles are being applied during the case. This case really set that standard, right? Moving on to our last little section here. So we're revisiting basically all those different ideas that we talked about in section 5.5, right? With judicial review, grounds for that. When we were talking about, like jurisdiction, statutory interpretation, legal principles, and kind of their concepts, just a little bit. So. Again, judicial review is a process where courts determine whether an administrative body's decision was made within its legal authority, so intra vires, or beyond its powers, ultra vires. Courts review administrative decisions to ensure fairness, legality, and compliance. What are the grounds for judicial review within administrative bodies, or upon administrative bodies, right? Administrative decisions can be challenged for a lot of reasons, such as natural justice violations, right, or the failure to provide fair hearings or impartial decision making. Judicial review can happen because of procedural unfairness, right, where a breach of due process in decision making was made by one of these administrative boards, and judicial review is then executed. The administrative board exceeding their authority, so ultra vires, and acting beyond its legally granted powers, or it having an error in law, right, misinterpreting legal principles. Yeah. Yeah. So again, the grounds for judicial review are the natural justice violations, procedural unfairness, exceeding authority, or ultra vires and errors of law. What are a couple key cases in judicial review that we looked at? One is Sumar versus the City of Quebec. It's about the municipal government jurisdiction and ultra vires. So the City of Quebec essentially tried to make literature on the streets subject to the chief of police with regards to the determining of the distribution of material. The Supreme Court determined you can't do that due to it being outside of the municipal government's jurisdiction. This is a case of ultra vires. So again, essentially, chief police wanted to essentially determine what can and can't be distributed publicly with regards to literature, and that is obviously outside of the City of Quebec's jurisdiction. Then we have Thomas versus Mount St. Vincent University. This is about legal fairness and appeal impartiality. Essentially, the professor was contracted for years, but when it came to a tenured position, the university said the professor is inadequate, despite being consistently recontracted. The professor appealed to the Senate Review of the university, which determined that the professor should be granted tenure. However, the university president said the opposite. The Nova Scotia court then determined that the appeal committee was illegitimate, as appeals are meant to be binding in nature, and the president was able to nullify it. So again, the appeal committee said yeah, the president said no, and that undid what the appeal committee said. Therefore, the court decided that the appeal committee must be illegitimate because the president was able to nullify it. What is in question here? It is legal fairness, right? You have the right to an appeal by an impartial body, and in this case, that did not happen. What good is the appeal process if it isn't impartial at all, right? Legal fairness and appeal impartiality. That is our lecture on administrative bodies, administrative law, and administrative, judicial review within these things, right? Yeah, see you guys in family law.